Stephanie Ambrose, America's Senior Home Coach, born and raised in Wichita, and I'm coaching realtors and other professionals every single morning all across all 50 states on some of these topics. And this seminar was so popular 5 years ago, it became a PBS television show, Empowering Seniors, which is so awesome for PBS to support seniors, to support us as we age. I talked to a PBS station in another city, a couple states away, and I wrote out who they are. But I needed to call them for something very, very specific. And I said, by the way, we do this show. And then we have a sister show, because Empowering Seniors was so popular, we have a sister show, Ageless Enthusiasm, which is really designed for boomers and Gen X. And we have these two shows, and is that something that your PBS would be interested in? And she said, no, she said, I'm 60, and I just wouldn't be interested in any of that. She said, I like positive aging, and I don't want to hear about anything negative. And she said, and we're trying to develop shows for a young audience, because PBS traditionally, except for the kids programming, has been for educated, more mature people, and they want to go after the young people. Well, I think that's awesome. I really think that's awesome. I think PBS should do that. But guess where the money comes from? The tried and true PBS viewers. We are having the greatest wealth transfer in humankind right now, with the boomers and their parents' generation downsizing and going through the whole, process, the whole journey here. And that's the people that are really funding public broadcasting. So anyway, interesting. Isn't that interesting? Do you think people are in denial about aging? Yeah. Way denial. Way denial. What do you think about that? Is it a privilege to be here? Yeah, year after year. It's okay sticking around.
No, it is. It is. You just don't be stupid about it. Inform yourself. Stay healthy. Do things. Don't just acquiesce and say, oh, well, I'm getting old.
I'm glad you said that, because I might be just a little bit younger than just a few of you. Maybe. I'm younger than my mother. She would hope so. And I hear a lot of people like my age say, well, I thought I should do that because of my age. That panics me a little bit, so maybe I'm in denial. Because I'm like, oh, should I be making different decisions, or thinking differently about myself because of our age? They kind of freak me out a little bit. And they'll say, I can't wait to retire. Oh my God, I can't wait to retire. I do not want to retire. That's why I'm doing this, because I can age, I think, as we go. Let's turn those lights down just a little bit so we can see the slides better. Because I figure that maybe the people I'm working with, it'll be okay with them as I get more wrinkles and whatever happens, and they'll still like me and work with me. Because my career has been real estate my whole life. I've kind of got off the beaten path, and now my husband and daughter Jillian are doing all of the real estate, and I'm out just teaching and producing television and things like that, because there's so much involved with aging. But we all age differently. In fact, I just started to read a book called Stage Not Age. And so this might be a book that you can get on the old Amazon, or call Barnes & Noble and see if they have it, or if they can get it for you, or ask the library to get it for you. Stage Not Age, written by Susan Wilner Golden. How to Understand and Serve People Over 60, the fastest growing, most dynamic market in the world. It's very interesting. And let's talk about stage, not age, because part of it is remaining joyful. We just happen to have a professional here that specializes We put her on the spot. Specializes in joy. Did you know there was a joy expert? That would be this lady, Constance, perhaps.
Thank you, Catherine. So this is impromptu, and I think that that is paramount. While we age, we have to keep that joy in our hearts. And every morning, every day, I recommit to it. So I make sure that before I leave the house, I smile really big in the mirror. And then I take that smile outside to the world.
And yes, she does. If you're on social media, you should follow her. She's crazy, like she's up early downtown exercising in the cold weather and observing all the amazing things in Wichita. She lives what she says. She has mindfulness coaching, and I think joy every time I see her. Joy, joy, joy. And that's because her life has been perfect and nothing sad has ever happened. No, that's not true. Despite everything, she's still joy. Constance, thank you for being here today. All right, so if you can, please silence your phones so we don't have those going off while people are trying to hear. I think there might be a couple people that are a little hard of hearing, so maybe a couple. So, okay, so these are our education partners. Bluestem Communities, which is amazing. Out of Newton, Heston, they have adult day services in Hutchinson, and I'm probably behind because they're always building and doing something. American Senior Benefits back here, they're experts in insurance and annuities. Oxford Senior Living, they were the first ones to arrive today and set up their table. The Regent, beautiful place, beautiful on the east side of town. Providence, Pam, and they just did a wonderful show for PBS that's going to be coming out in season 4. Sedgwick Plaza on the east side. Morris Lang Law Firm, thank you Jackson for being here. Catholic Adult Day Services, woohoo! You are so great about being here every month and such a wonderful supporter. So we probably want to bring you into part of this conversation today as well. I'd like for all of our education professionals to chime in today. Fleece and Gooing. And then our television sponsors for last season, American Senior Benefits, Bluestem, Sedgwick Plaza, and Fleece and Gooing. Thank you very much. All right. Okay, I'm going the wrong way. All right, so we do everything to do, my husband, daughter, and I, we do everything to do with housing, quality of life. You literally can call us for anything. One phone number, and that is on everything, and we'll get you the people that you need to know. All right, we actually we're down to the final one. The final one, we just did Tuesday, cashing in on the American Dream. So some of y'all were there. Thank you for being there. So we have some really great candid conversations in that class. We do that at this television station. And that is not correct. December, I'm sorry, it is. For Downsizers Club. December 12th at the TV station, we're doing this stuff. Liquidating your extra stuff and our best packing and moving tips. So that'll be a good one where we can actually teach you how to pack yourself, how to save a lot of money. We'll teach you everything that we've learned by moving about 150 people from all of our training. All right, that's the Tuesday before senior seminar. And then we'll come up with a new schedule for next year. If you'd like to be a volunteer, be an ambassador, I'd really like to expand the ambassadors program and make it really fun and have you be as engaged as you want to be. All right, Jackson Eli with Morris Lang, guest over here today. And then if Amy DeWald and Jason Bach would come on up. Randy, I think we might just need 2 chairs. I'll move 2 over. If we add somebody, we'll bring it up. If you each would do an introduction and share what you'd like to share right off the get-go, and then we'll have you take a seat, and then we'll start quizzing you guys. Would you like to quiz them? You're pretty good at that. So they'll be on the hot seats today. We appreciate it. Okay, and you've got some slides. Okay.
Test, can you hear me? Okay. Glad to see everyone out today. We attend this regularly, and the opportunity, when it presented itself for us to come up and spend a little more time talking about what we do and answering questions that you have, we seized on that opportunity. So if we could just advance the slide, we'll introduce ourselves and our... Can we go back one? There we go. Is that okay? All right. Well, yeah. My name is Jason Bach. My partner here, Amy DeWald. A little bit about ourselves. We both practice in the area of estate and trust law. I advise clients in terms of planning, also after death, when there's needs to administer estates. Also, a large part of my practice is dealing with contested matters. So when things don't go quite right with estates, trusts, guardianships, folks hire me to help resolve those matters. I'll let Amy say a couple words about herself.
Hi everyone, thanks for having us today. As Jason mentioned, I'm Amy DeWald. I'm also an attorney at Fleeson Gilling. I have been at Fleeson for a little over 5 years, primarily in estate planning and then probate and trust administration, which we'll explain those in just a little bit. I have a passion for estate planning and helping my clients work through various issues and leave, hopefully, with peace of mind that they're taken care of and their family's going to be super happy at the end of the day. And then I also do a little bit of business transaction work and adult and minor adoptions as well as part of my practice. We're excited to be here today and feel free to ask questions. We love an engaged and interactive audience.
Yeah, and so we'll take just a quick opportunity before we get started here to plug our firm as a whole as well. We are 2 of 24 attorneys in our firm, so we are a full-service firm. So although the faces, people you see here are generally in estate and trust planning-related law, we cover the gamut. So litigation, real estate, tax, across the board. We've got an attorney at our firm that can help you. So we also passed around and put on the table a info sheet with some information that we're going to cover some of this today. This isn't something that you're going to need to follow along, but this is for you to take, and wanted to, on the one side, just have some general comments and descriptions about various estate planning documents and tools that you may have heard about, may have questions about. This isn't going to answer all of your questions, but it's going to get you thinking about them. And then on the back, an estate planning checklist that provides some questions, and the idea is to sort of get you thinking about certain things in your own life and with your own estate planning. And so we thought this would be useful. Again, we're going to touch on some of these topics, but this isn't something that's going to be necessary for you to have in front of you while we're talking today, but to take with you and for future reference.
If you don't have one on your desk, we have extras on our back table. Oh, we just ran out, but we'll be happy to get some to you if you want extra copies or if you didn't get one today.
So we will hand out evaluations or survey forms towards the end, and you can just, if you don't talk to them directly about getting one of those, just write it on your sheet that you want a copy, and they'll get it to you. We'll get that to them.
Absolutely. So there was something that Catherine mentioned that I think is appropriate to sort of for us to kind of lead with, and that's the denial of aging, right? And one of the most common things I would say that I hear when I sit down with folks, typically if they're older, they say this one thing, and can anybody guess what it is? We've needed to do this for a long time and we just haven't done it. So it's so true that it is something that people put off. But I will say that 9 to 10 times out of 10, when we get done and we have the documents in place, they say, that was easier than I thought. I wish I would have done it a long time ago, and I feel a lot better now. So, thinking about these things, I thought of, well, let's use some quotes, and so I pulled a quote from Woody Allen. He said something kind of funny. He said, "I'm not afraid of dying. I just don't want to be there when it happens." So, and that's kind of the approach that I think a lot of people have with this. And while funny and relatable, it's not really how would be a prudent way to approach these things. Another quote. So we'll sort of move along. Ben Franklin, what did he say? Nothing certain in life but death and taxes, right? So the death part is true. The taxes, I could introduce him if he was around to somebody named Jeff Bezos and Tim Cook, and so he may find that those aren't all certain. But last quote. This is the quote that I think is one that should guide you in this process. Peter Drucker, he was kind of known as the father of business management, but I think it's just as applicable in the estate planning world. And it is the best way to predict the future is to plan for the future. And so it's not something that we should shy away from, but we need to confront it, and we need to get our affairs in order. So there are some questions, I think, that are helpful to ask yourself when thinking about estate planning. And a lot of people in this room, they're here. All of you are here attending this presentation. A lot of familiar faces. A lot of you regularly attend. So you are ones who maybe think about this more than others. But consider what's going to happen after I'm gone, and is my property going to pass where I want it to? That's a good question to ask yourself. Is the way my property going to pass, is that consistent with my goals, values, and objectives? A lot of people, maybe name beneficiaries, and maybe they have something on an account with them, and it's really somewhat discombobulated and not organized, and they just, again, they take the Woody Allen approach, and they don't want to think about it. Have you discussed it with your family? People's family dynamics are different, but have you discussed it with your family, loved ones? And if they're playing a role, which they probably will be, have you discussed what their role is? Make sure they understand what that is and are comfortable with that. You have also considerations of balancing things like, I want to leave property, I want to bless my family, but can I balance that with maybe there's a concern of management of that? So maybe there's some tools that we can put in place that can help you manage that property continually. Maybe it's a minor, maybe it's a child that has some vices of some sort, or for whatever reason, you think, I don't just want to, leave them a lump sum when I'm gone. It wouldn't be good for them. And you'd be surprised. People who own a home, you have a life insurance policy, while you're alive, oftentimes people think, well, I don't have a lot of money, a lot of resources. Well, you're living in a home, maybe you own that home, maybe you have a life insurance policy. So all of a sudden, when you're gone, now there is a bit of assets there that people may be unfamiliar, unaccustomed to, just sort of landing in their lap. So I've seen that a lot, where people do, and I'm sure everybody in this room, if not most of you in this room, have seen situations like that, where somebody gets a chunk of money, it's more money than they've ever received, and they think it'll last forever. So they get a new car, and they take a nice vacation, and next month it's gone. So these are some of the questions. At the end of our presentation, we're going to open it up, question and answers. But first, and today we wanted to cover a lot of the topics, questions that people have who we meet with. Amy and I talked about this, and we said, well, why don't we make this kind of like we're sitting down with clients and talking about things with them. And people come to us with all sorts of different backgrounds and understanding about estate planning. Sometimes people come and say, I don't know anything. I haven't thought about this. Others come in with a plan, and sometimes that's a good plan, and we just help them implement it. Sometimes we can identify things where maybe we want to tweak this, or have you thought of that? So one thing that is sort of present in most people's minds, and it's a word that everybody seems to know, but have maybe different conceptions about it and different feelings about it. That's probate, right? Is it a dirty word? Some say, avoid it at all costs. But it's important to understand exactly what it is. If you want to avoid it, how to avoid it. What's a smart way to avoid it? What's maybe a less smart way to avoid it that might result in some unintended consequences. So I promise everyone here, I am going to let Amy speak here in a moment. But we decided I would talk about this slide, and she could jump in. I could forget to say something, or God forbid, say something wrong. She's here to correct me. But probate is generally, as I describe to clients, it's a legal proceeding that's necessary to take title from out of your name when you're gone and put it in somebody else's name. Pass it to who is entitled to it. You're gone. When you're alive and you own property, you can transfer it. You're oftentimes the only person who can transfer it. So when you're gone, there's nobody there to transfer it anymore. So the legal proceedings called probate is the process by which that's done. That's one aspect of it. But also the administration of your estate. Oftentimes you leave things that can't just pass. Maybe you have a house full of things. Maybe you have various accounts around, checking a savings account here, maybe an old checking account you used to use for something that's got a little money in it, retirement accounts, maybe there's beneficiary designations, maybe not, house, vehicles. Well, these things have to be managed, administered, oftentimes liquidated, and turned into cash. It's hard to split a car up if you have 3 kids, you guys all take the Buick. It's not ideal. Also, assets have to be liquidated to, oftentimes, maybe there's creditors. Sometimes there's medical bills. There may be a nursing home bill that's left. And those creditors have to be given notice and an opportunity to present claims. So there's that aspect of it too. Final tax returns. Your personal representative who's appointed for your estate will file your final tax return. And also, as I mentioned before, determining heirs and admitting wills. So if you don't have a will, your property is going to go through probate, and the people who are going to receive the property after creditors are paid and costs and those sorts of things are going to be your heirs at law. And sometimes that's not what people really want. And even if you love everyone in your family, we'll say nuclear family, wife, husband, and some kids, a lot of people don't realize if you don't have a will, your heirs are your spouse and your kids, 50-50. And that's not what I have. I can say, I cannot think of a time that I told that to somebody and they said, yeah, that's what I want. When I die, I want half of my stuff to go to my kids and for my spouse to just be left with half of what we had. Oftentimes, it's they think when I die, everything will go to my spouse, and then when my spouse dies, everything will go to the kids. And so a will is a tool to avoid that. And then finally, distribution of assets. It's that process of finally we've administered the estate, we've determined the heirs or will beneficiaries, and now assets are distributed. And there's pros and cons to probate. It takes some time. When you open probate, you have to publish notice, and creditors are often given 4 months to file claims in the estate. Even the most simple and smoothest probate is generally not going to be able to be concluded until 6 months from date of death. So there's some time there. Although in Kansas there are some procedures available for smaller estates that can kind of expedite that process and speed it along. But some people try to avoid probate at all costs. The goal is, we don't like probate. That's a dirty word. What do we have to avoid that? And I, at times, counsel people, maybe you don't want to avoid it. Maybe your circumstances are such that probate's okay. We'll talk about trust a little later, but I've seen folks spend a lot of money, make a complicated estate plan just to avoid probate. And so I think it's important to really educate somebody on what probate really is and whether you avoid it at all costs. So some people want to, and we'll talk about when you absolutely want to, but it's not the dirty word that a lot of people may think it is. So I'm gonna turn it over to Amy, like I promised all you, and I told her beforehand that I can get windy, but I swear I'll let her talk. She's gonna discuss some ways of transferring property and some different tools and instruments that are available to do that. So I'll hand it over to Amy, and
Yeah, you can even take a seat there if you want to, Jason, because we'll want to ask you questions. Write down some questions on your scrap paper there so that when Amy does her introduction here, then you can start getting those questions asked. And then we probably want to hear a little gossip too. Like, you don't have to name names, but maybe tell us some of your most interesting stories, because that's how things really hit home. All right.
Thank you very much. So I'm going to kind of follow up on a few of these things on this slide. I'm not going to spend a ton of time on a few of these. We've covered a little bit with Jason earlier. But the first one is the last will and testament. And Jason kind of briefly described what a last will and testament is. This is what most people automatically think of when they hear estate planning. Oh, my will. And so that is a document that you draft, and you name a trusted person, your executor, to handle your affairs at the time of your death. Again, a will needs to go through the probate process. I completely agree with Jason. The probate process is extremely useful in many situations. In Kansas and specifically in Sedgwick County, we have a really great judge who doesn't waste any time and gets us through that probate process in our timeline. And so families can have some closure at the end of that process. I think one of the main benefits of having a will, and we'll kind of contrast this to having a revocable living trust here in a bit, but with a will, our clients can come in, we can discuss all of their intents, all of their wishes, memorialize that in a document, and then essentially, they're almost done with their estate planning. There's a few other documents we'll discuss that are especially useful, but a will is in effect, and then it kind of hangs out until you pass away. Of course, review it and revise it. Make sure the people named as your executor, your successor executors, are up to date, and that it does describe where your property is to go. So, keep reviewing and making sure it's current with your wishes, but you can essentially sleep at night and have peace of mind. My estate planning is in place, and I've done that work, and it's gonna be administered the way that I want it to. Like I said, we'll kind of contrast that with a revocable trust. There's some ongoing things that need to be done with a revocable trust. The second topic on this slide is joint ownership with survivorship, and you may think, I kind of know what that means, but the perfect example is when we're talking about real estate. A common way to title real estate, especially with spouses, is to have this joint ownership with rights of survivorship. And I have clients all the time who aren't exactly sure what their deed says, a married couple, and they think, well, sure, yeah, of course. When I pass away, my spouse is gonna get the house. And I say, well, let's back up and let's pull the deed and let's look at it and make sure it has proper language on the deed. You're looking for the language joint tenants with rights of survivorship and not as tenants in common. What this does is when the first spouse passes away, the surviving spouse automatically has that right to become the sole owner, the right of survivorship. they become the sole owner, with the filing of a death certificate with the Register of Deeds. And so that surviving spouse can sell the house at a later time, and make all arrangements that they could do when their spouse was living. So we have found situations where maybe it was, when you purchased the house, it wasn't titled that way for whatever reason. And so if it's not titled that way, you want to make sure as part of your estate planning, if it's your intent, of course, to have your spouse have the opportunity and be able to stay in the house in addition to what spousal rights they have, we want to make sure that that deed is correct. We'll jump on to beneficiary designations. This is extremely important with all estate planning. You want to make sure that all of your accounts, investments, all of the policies that you hold in your name have a beneficiary designation. And by that I mean you have named someone that will receive and have that policy or account distributed to them upon your death. Make sure these are current. Has your primary designated beneficiary passed away? Do you need to update that? Do you have successors or contingent beneficiaries on these accounts? It's very important to make sure these are updated, and these can avoid the probate process by having these named beneficiaries. What happens without?
Well, I was gonna just jump in.
Sure.
And just make one comment on that. Another something about beneficiary designations is that sometimes they seem like, I hope you weren't getting to this, I thought maybe you were moving
Take it
on.
away.
So, sometimes beneficiary designations, I talked about sometimes people avoid probate, they put in an expensive, complicated estate plan, maybe more than they need to avoid probate. Others do it, maybe say, I can use beneficiary designations. And it works sometimes, and other times it's a little inflexible. So what happens if you have maybe multiple accounts and you say, I'm gonna leave this one for my son, this one for my daughter, and you have different beneficiaries, but then maybe you become impaired and somebody's managing your affairs and they're using money to pay for your cost of care. Where do they pull that from? Are they gonna pull it from this account? Occasionally I've seen where there's the son or daughter who is the appointed agent who makes those decisions. And there is, unsurprisingly, a tendency or an inclination to say, if it's the daughter, oh, maybe we use this account over here that brother's the beneficiary on and pay mom's care or dad's care out of that account. So you run into those issues where you may be a little inflexible, and also those accounts change. So unless you have all equal beneficiaries across those accounts, what was the case when you set those beneficiary designations up may not be the case after you're gone. And so it certainly is a way to avoid probate, but it's something you've got to keep an eye on, and you got to think about that. And especially if there's maybe a taxable account, maybe an IRA or 401k, well, those are going to be taxable to the beneficiary. And maybe there's a savings account. And so somebody at one point in time may have to make a decision. Well, what's in mom or dad's best interest to pull money out of? And so that could inadvertently change change your estate plan. And so I'll hand it back over. I will say, I bet when Amy's going through the rest of this stuff, if a hand pops up, she'll stop and answer that question. So if anybody has any questions as we're going on, feel free to let us know.
Thank you, Jason. We'll jump on to.
We've got a taker on that offer.
What are your thoughts on transfer on death deeds? Repeat the question, please.
The question was asked, what are your thoughts on transfer on death deeds? I know Jason will chime in here on his thoughts. As part of an estate plan, it's going to depend on what your intention is. If you are leaving your real estate to a single individual, I will typically say it is best to have a transfer on death deed. if it's clear and concise, it's going to this person. Why I say a single individual, it can obviously be done by transferring on death to multiple individuals, such as multiple children, but it does get complicated when that happens, because in Kansas, spouses have rights in real estate to what their spouse owns. So for example, if you have three adult children and they're all married, and you leave it to the three adult children, and then they later want to sell it, now 6 people have to sign off and agree to the sale, agree, to the terms of the sale, and it can just get a little bit complicated. And so,
that gives the real estate agents headaches.
so we try to have these conversations and work through, what's best for our client. And that's in the setting of if you have a last will and testament. If you have a revocable trust, it's different. You can title it in the name of the trust. It's funded within the trust, and then that trustee that you have named, that trusted person in your trust, has the authority to make decisions and either sell or distribute as the terms of your trust would say.
We got another one over here.
With blended families, is it possible to set up executives?
Yeah, so the question, sure, the question is, with blended families, is it possible to set up co-executors? I tell my clients it's possible to do almost anything when it comes to that. Some things are advisable and some things not so much. That's one. I don't know if Amy was gonna touch on this or not. I let you.
You can work in a wrestling contest as part of that agreement.
So there's a lot of considerations when you name 2 people in any fiduciary capacity, whether that's under a will, a power of attorney, which we'll hopefully talk about later on. Are these two people, they're your children or friends or other relatives, do they get along? Do they see eye to eye on situations? Is it going to cause conflict or confusion? There are different dynamics at play. How are you going to grant their authority? Are you going to allow them to act independently for decisions? Are you going to require them to agree on all decisions? You may think, well, yes, let's have them agree. That way, they're both informed and they're making that decision. Well, what if something needs to be done very quickly, under a power of attorney or under some other document, and it says they're required to agree, or if they're just going to a bank and going to try to write a check, the seller is going to say, I need 2 signatures, from every decision, whether that's small to very large decisions. They would have to agree on everything. And so there's a dynamic at play. Maybe we get creative and you have them have to agree on major decisions, and you can determine what that might be. But then they can act independently in the day-to-day decisions. So we can get creative. Some people really do prefer having 2 acting at one time because of those checks and balances, or maybe they have 2 children and don't want to leave one out. But it's really important to consider, what all I've mentioned, and that you would have chosen either of them individually to take this on, because they would both be capable. These are very important responsibilities that come with all these documents, and so are they going to pay attention and work together well, is going to be kind of what it comes down to.
And do they have the temperament to handle it? Because when you say responsibilities, in a lot of ways what you're saying is burden. Because sometimes this can be the hardest thing that you do to your child or children or the executors. What other options are there that might be something to consider? And you mentioned something earlier. Your first response was, it depends. Could you write that down on your paper? It depends. It depends. And that's the answer for a lot of these questions. It depends. So we better sit down and have a conversation about our particular situation and probably revisiting it over time because it depends and we want to rely on professionals that can help us navigate things. And isn't it true that we save a lot of money if we work a lot of this up front than have a disaster later with people not getting along?
Absolutely, absolutely. And to be fair, we're sort of responding to your question because you premised it in a way that has some meaning and tells us that there's a reason for it when you said blended family. Oftentimes, I find clients think along those same lines. Let's have a representative from both sides of the family. And so already sort of baked into that cake is that there's different interests. And so you're appointing two people who may have different or maybe conflicting interests. And I have never seen that be a workable solution to that problem.
Unless they're like all into MMA. Do you know what that is?
Right.
Mixed martial arts.
Yeah. So and there is, and Amy touched on this too, co-executors, co-fiduciaries, that's not something to be avoided at all costs, but it's why you're doing it. Appointing co-fiduciaries can be a very good thing if it's for a matter of convenience. Maybe you want them both to have the authority. Maybe you want some flexibility. Maybe somebody's taking a 2-week vacation, or maybe somebody works a job that can be demanding at times, and you want two people to be assisting and helping manage. In that case, it's advisable, I think, and this is my recommendation to clients, is to give them both independent authority. Maybe on some big decisions like selling major assets or something like that, they both need to sign off on that. But on the day-to-day administration, you need to be able to trust either one of those to carry out. If you can't trust either one of them independently, and you're sort of using two to solve that, it rarely solves that, because what's a majority when you have two people? That's unanimous. So basically you're saying they have to agree on everything, so there's certainly some issues with it, but it can be done. Again, it somewhat depends on the situation. It depends on what the objective is in doing it. And so, I certainly have, for a number of clients, appointed co-fiduciaries, co-executors, and we craft it in such a way that's going to try to avoid conflicts and problems.
Right.
We got to.
And sometimes the kids get along before the major stress happens with catalyst event, medical issues, or dealing with things after someone's passed, and then maybe they don't ever get along again. And so there's a lot of things to think about. And sometimes while people say, well, if I die first, it'll all be okay, but if my husband dies first, there's going to be major problems. So it's good to kind of talk this over with an attorney and put a plan together.
Okay, so since you're talking about blended families, I gotta tell you guys this. If you heard anything that they said, I urge you, everyone, to check the deed to your house. I had the blended family thing. My husband died. We had bought our house 20 years before from a relocation for out of California. The people that were selling, a relocation company, sold it for his job. It had not the right of survivorship. It did not say that. Joint ownership with rights of survivorship. I couldn't even sell my house. I couldn't do anything unless I had my 2 stepsons and my son and their wives sign it. 6 people and me. That was 7 people that would have had to sign it. I had no idea the deed of my house was like that. So sorry to interrupt, but that's just, everybody should check the deed to your house.
Absolutely, and Amy and I can both tell stories of that very same situation. And there are times you cross your fingers because you're going to ask this next question. When you find that out, are your kids going to be okay with just signing that over to you?
And we've, unfortunately, we've had kids that sold the house.
That
Mom's moving.
And they're exactly. If one of them gets divorced, then that is an asset, a marital asset. Their interest in the house is a marital asset. So it causes all sorts of issues, and it's certainly something to be avoided.
And another thing that can happen in a divorce is that maybe the mortgage is in the husband's name, but the wife is keeping the house. And it's just a mess. These are things to deal with. So I want you to think about your grandchildren, because I mentioned at the beginning of this that this conversation today is only for the people that are 18 years of age or older. And the reason why is there's some other documents that we need to talk about too. The reason why sometimes one spouse isn't on like that is because there was a mortgage involved, the other person didn't qualify, so the mortgage is one person's name, so they're the ones that go on the title. But what can happen right there at the same closing title is they sign another document that's gonna fix that in a few days, or that something can be fixed later, and it's a very easy thing to do. So I'm glad we mentioned that.
Okay, we've got a question here in the back.
Actually, it's more of a comment and on the blended family thing. What my dad and stepmom did is they have one child together. So even though he's the youngest of the five of us, they have put him in charge of everything that happens afterwards. And since my stepmom can't manage money, he's also in charge of all her stuff afterwards too, if my dad were to go first, because he represents both sides.
So how does that make the other four siblings feel?
Well, we all like him, so, we all like him, so, and we all told him, we're here if you need us, but, please don't need us.
What kind of weird family do you have?
I have a very weird family. My brother, he lives in Maryland, and he and his wife have plenty of money, and they have their own family. My sister is kind of a self-proclaimed anarchist, political activist / gypsy, kind of runs around.
Now it's sounding more normal.
Yeah, and my other sister is an ex-con, married to an ex-con. And then there's me, I'm a military veteran, disabled, and then there's my little brother, he works at Honda. He has a wife who has 4 kids of her own, and then he's got 2 of his own from a previous relationship. So.
Wow, totally normal then.
I'd like to make just a quick comment. I think your family's awesome, and here's why. You're having these conversations. You know what the plan is for the future. I think that is wonderful that the individuals who made the estate plan have these conversations with the people that are first going to execute that estate plan, and second, those that will be affected by it. I mean, how many disputes did that possibly eliminate by just having these conversations?
After the massive heart attack issue, we had to have these conversations.
Okay, so catalyst helped that massive heart attack prompted the conversation. And still I say that's good because you started talking about it after that. Some families don't.
Yeah, so, and I would mention one other thing. It was brought up before about things change. I think Catherine may have said it, when somebody passes away, that is a stimuli, right? I mean, what's guaranteed is that's going to do something. Life is not going to continue for the people involved and close. It's not going to be the same afterwards. Now, sometimes maybe people ignore it, they're in denial. Sometimes it brings families together, sometimes it pushes families apart. But what is certain is there is going to be emotion. There is going to be strong feelings. And there's also a job that needs to be done. Whoever passed away, they have an estate that needs to be distributed and handled and managed appropriately, fairly, in accordance with the law. These are not ideal times for emotions to be driving people's decisions. And so that's what I tell folks, when a death occurs and there's close people, it's going to have an effect. And it's going to have an effect. And so it's not the time to maybe be rolling the dice and hoping that a sort of duct tape together estate plan works. It's not the time to do it. You want to have something in place that even it's going to work, or it has a high success rate anyway, nothing's guaranteed, but it's going to have a high success of working, even if these people don't get along, even if these people don't want to be doing this. That you've thought about that, you've got something in place that'll work.
Excellent. We just had a TV guest recently who's an expert in this area of real estate, and he said the best families that get along sometimes don't get along when all this stuff is happening. And wouldn't it be nice to just have people have the ability to grieve and comfort each other and hug each other, hopefully, and not have to deal with major crises where they feel like they need to be in defense mode or emergency management mode. All right, we've got a question here now, then I'll come back to Lillian.
So my quick question is, basically, if you've moved recently from one state to another state, how often do you have to update that will, and how does probate work if you're in, like say I'm living here, but my adult kids live in 2 other states, how does that work?
Yes, so the kids being in other states is not really an issue legally speaking. I mean, just practically it could be, you know, particularly if you pass away in one state and your kid, maybe who you appointed to be the representative of your state, lives in another state. You know, it can be done, but oftentimes they're flying back, and it kind of depends on what your estate looks like, right? I mean, I tell people, the best way you can pass away is in a little apartment with not a lot of stuff and a whole bunch of money in an investment account. That's great. You know, that could be administered from, you know, across the world almost. So it can be done. And in terms of wills, updating wills, you know, it is advisable to have a will maybe reviewed if you're coming from another state or a trust, but we have the full faith and credit clause of the Constitution, and we have laws in the state of Kansas that says so long as a will or other trust document was executed in conformance with Kansas law or in the law of the jurisdiction in which it was prepared, then it's valid in Kansas.
Awesome.
So.
Did that answer your question? Okay, very good. Lillian, did you have a question up front?
Yeah.
Okay, come on, Mike. Would you like to stand?
Cycling back to number 1, could you explain the dynamics briefly? If you have a will document, how it still requires probate? Because the impression publicly is that if you have a will, you don't go through probate.
I think that's a great point. That's one of the first things when I'm explaining things with a new client. That's one of the first things that I try to mention. There's a very common misconception. I have my will done. I am good to go. It's going to be like the movies. My executor is going to read through it, and we're just going to start taking things, and everyone's just going to be fine. And if they're not fine, too bad. But it is not like that. In the state of Kansas, when a will has been properly drafted and executed and is still in effect, when a person passes away, it needs to go through the probate process, and it actually needs to be filed with the court within 6 months of the person's date of death. You know, there are laws. If that doesn't happen, you know, that's a different conversation. But the main rule is it needs to be filed with the probate court. And that estate needs to start being probated within 6 months. And so that is a really important thing to discuss with your executor. You know, that there are duties such as filing this will with the probate court, and there is a timeline for doing it. There are a lot of timelines that are triggered, and that kind of goes hand in hand with the creditor's ability to make a claim against an estate as well. So there are quite a few moving parts, but yes, very clear when you have a last will and testament, a probate proceeding is involved. If the best case scenario, all of your assets have a beneficiary designation, you have a transfer on death deed, everything is taken care of, but you still have your will drafted, we highly recommend it still filing that will with the court to preserve it. And it is not actually probated. There's not an ongoing proceeding, but you're preserving it with the court in case at a later date an asset is discovered. I've had this happen a few times now, where a client passed away, we preserved his will, and then he later inherited oil and gas interests. And thank goodness we preserved that will, because we were able to follow his instructions a couple years later and make sure that it went to the proper individuals he had named. And so you're spending the time putting this estate plan together, you might as well preserve that will and make sure that it's useful later than 6 months from your date of death.
Yeah, and I'll just mention something on that. I think it's helpful to understand, this idea, well, I have a will so we don't have to go through probate. But if you think about it, it's called a last will and testament, first of all. So that contemplates there could be more than one. So when somebody says, here's the will, well, who says that's the will? Is it properly executed? Is it a valid will? Who determines that? The court does. So under Kansas law and the laws of, I think, every other state, a will has to be admitted, and then it has to be offered to probate, and then admitted by the court to probate that says this is the valid will. And in fact, you have in Kansas up to 6 months to offer a will. So somebody theoretically could offer a will that was signed in 1997, and it's admitted to probate, and somebody comes in 5 months later and says, here's one executed in 2019 that revoked that one. That's the valid will. So it's important to understand wills have to go through probate, and it's not a will until the court says it's a will.
And where should these wills be kept? Locked in a safety deposit box and nobody has a key? Or is there a better idea?
I suggest you bury it in your yard and you leave a little map.
Write that down?
Yeah. And then you say you got 6 months to find it. No, that's not. It needs to be accessible. People have to know where these documents are. That's a big mistake people make. I have people who come in, somebody's passed away, and they say, I don't know if mom or dad had a will. I'm going through the file cabinets. I don't know if they had a safe deposit box. Maybe they did, maybe they didn't. So you gotta let people know how to find that will, because the clock's a ticking.
That's one of the things I always talk about is like being a good parent. That, when we're expecting a baby, we read the book and try to figure out how we're going to be a good parent. And can we be a good parent to the best of our ability as we age, or in case something unexpected happens, so we're not leaving somebody in a crisis that's going to cause them a tremendous amount of stress.
Can you continue to number 4?
Yeah, we'll do that. We'll take this question and we'll move on to revocable, because the next slide goes into that in a little more detail.
Red Hat Lady Queen Connie, and I'll come over there as well.
Back to the rental property, we have rental property. Should we put it in our living trust or just leave it out? We're probably gonna be selling some of it, but right now it's just all rental. My son passed away 3 years ago, so we're just in the process of redoing our living trust.
Well, we have to have an additional conversation, maybe about some details to really give you legal advice on that and what we think would be best. But I mean, certainly when you have a trust, which we'll be talking about, the idea is that you put all of your property into that trust. Now, it may be the case that you have a rental property that then you have be owned by an LLC, limited liability company, that then is put into the trust to provide some liability protection. But those are some of the things that, we or, another lawyer, any other lawyer would be happy to sit down and kind of work through some of those issues to make sure that that's best for your situation and what you want to do.
I will tell you with real estate, a lot of times too, we'd be happy to do a free consult, is that a lot of times people want to simplify their estate to make it an easier estate to leave. And it can be very, very stressful, to say the least, if, let's say, the husband dies very unexpectedly and leaves his wife with a lot of properties to deal with. It is very stressful. So I'll come right to you in just a second. We've got Joan here with the question.
Well, you were talking about the timeline on probate. What if the person dies without a will? How do you get probate started? How quickly do you have to? What if they're out there trying to settle things without having done anything?
Right, so Jason mentioned just briefly at the very beginning of our presentation that there's a set of laws that govern this situation. And the person is considered, the person has died intestate without estate planning. And so someone from the family or someone involved who knows this person's situation will need to initiate proceedings in the probate court. This person's referred to as an administrator. Again, there can be issues with, who's going to be appointed as administrator, or are people going to fight about it? So the court has that oversight, and once an administrator is involved, it's a similar process as if you'd have a will, but the court has a lot more involvement. Every time you sell personal property, every time you sell real estate, if there's a family dispute, all of that has a set of pleadings that need to be filed with the court and approved by the judge. If people disagree, hearings will be set. And so there is a process for that, and we handle those as well. If the will can't be found, or if there just is, it's clear there's no estate planning in place, we go through a similar process, an administration process, with creditor timelines and with publication notices to creditors and all that. Do you have a follow-up?
Well, the question really is, how do you start that when there's only a spouse, no kids, and she doesn't want to go to an attorney?
So the question is, how do you start that? If there's only a spouse, and you said they do not want to go to an attorney? Because my advice would be talk with an attorney, and get informed on if you are going to become the administrator, what are your duties and what do you need to do. To initiate a probate proceeding, there needs to be pleadings filed with the court if there's assets that are in this person's name that need to be distributed. Of course, you can contact the court as well, but it's going to be more difficult to know which pleadings are necessary and what steps need to be taken with regard to all the assets.
And the court's not going to give you a lot of guidance. Often, if you call into the court's going to say you need to talk to an attorney. And so there are some services, Kansas Legal Services, that you might call and be able to get some advice there. Kansas, unfortunately, a state like Colorado is much more form and pro se, unrepresented party friendly, where you actually can more easily administer small and simple estates by going to the courthouse. They have forms that can help you out with that. Kansas, for whatever reason, we have not moved to that so that it is easier for simple estates to be administered by somebody without an attorney. So I get calls often where somebody called the court, they tried to figure it out, and the court clerk says, you got to go talk to an attorney.
So you can also, I missed part of that, but you can also use a little leverage. If at some point you're working with, say, Comfort Keepers, Providence, Catholic Diocese Adult Day Services, you're working with Cherie, Anitra back there, Brian Spear, I don't know where he went, but I'm really thankful that he ran our seminar last month. We thank you for letting him do that for us. Oh, there he is on the phone, of course. So, and then we run a nonprofit 501c3 Empowered Senior. Use us, use the other professionals for leverage to help, to allow us maybe to engage in a conversation that might allow somebody to make a better decision, which leads to them calling these guys.
And I'll mention, I know you premised it on intestacy and intestate estate. Another reason why Amy and I would both say almost everyone should have a will, even a simple will. And part of the reason why is if you have to go through probate, it costs. You will have to have an attorney involved, but if there is a will, there are a lot of things that will can do to make that process much smoother. One, the person who you want to serve is going to be appointed unless there's some major issue with them and the court won't appoint them. But two, selling assets, as Amy mentioned, Personal property, real estate, your will can say, my executor can sell real estate without any involvement of the court. Now, you still have to have probate proceedings, but without a will, you have to have additional proceedings to sell things like real estate and personal property. And so you can really make that process less expensive. Also, without a will, your personal representative has to get a surety bond unless it's waived by all of the heirs. And that basically is an insurance policy they have to get that protects the assets in the estate. So the court says, if I'm appointing you over, and there's $100,000 in personal property or liquid assets or financial accounts, you have to be bonded for 125% of that value. And those bond premiums can be, for on an estate that size, maybe, $1,500 just for the bond premium, just for the insurance. And so those things can be, the cost of the will right there saves that, to be able to avoid that.
And that can be a burden when someone's passed away and their loved ones are having to pay costs out of their own pocket because things weren't done correctly up front. Carl Turner has a question.
My brother passed away, and his widow, my brother didn't have a trust or a will at all. He had nothing. I don't know if it was ever went to probate or how it did, but my sister-in-law started selling farm equipment and animals and stuff about 6 months after his death with no authorization. I don't know if they're in trouble. Well, another thing, some of my property was sold with that, which is okay. I wiped that clean, that's okay. But are they in trouble for selling stuff without the probate okaying it?
Well, yeah, it depends. Here's what the conversation, how it sort of goes with folks in a situation like that. Now, farm equipment is kind of a unique one because it's one of these types of property that is untitled, and so it's untitled for anybody. You hook it up and pull it. Need somebody? Here's the check. Here's your disc or your drill or whatever it is. Here you go. So tangible personal property, it's untitled. It can be good. It can be bad. A lot of times it's bad because you have issues with, well, the diamond ring, where's that? Or dad had, 5 firearms here, they're gone. And there's no really way to prove or track that those should have been there. Probate, there's no probate police, right? There's nobody that comes in and says, oh, somebody did something wrong here. It's really a self sort of monitoring process where it's the heirs involved. They all have rights, and if somebody's doing something wrong, somebody's selling property that they have an interest in, then they can go to the probate court, commence proceedings, and address it in that probate process. So,
And this was something I was going to say earlier, is that every home has trash and treasures. The treasures disappear really fast, usually. And, hurt feelings can last decades. Like, Grandpa left me that gun, and I don't know what happened to it, or somebody else got it. And so the more you can do to leave people with some peace, or give some of those things away in advance, that could be good. And aren't there some documents that we need before we pass away? That's why I mentioned the 18-year-old scenario. What kind of paperwork should a young person have, once they are an adult, so that everyone's educated on that? What are the essential documents to have in addition to these things after you die? And I wanted to thank the Catholic Diocese Adult Day Services for bringing the file of life. The firemen are trained to look for these, paramedics are trained to look for these. This is a big clue for anybody that might need it, to have this maybe on your refrigerator, for you to have your healthcare proxy, living will, do not resuscitate order, durable power of attorney, and some other things, very important documents that would be easy to find. And so that's what I was hoping you could address, is the healthcare proxy and so forth.
Sure, we'd be happy to jump to that, and then if we have a little time, come back to revocable trust to finish that out. So I will first talk about durable power of attorney for healthcare. So everything related to healthcare. What does this document do? Well, this document allows you to name a trusted person, which is going to be referred to as your agent, to make decisions for your medical needs. This is everything from assisting you with decisions for treatment or withdrawing from treatment, assisting with living arrangements, making appointments, assisting with prescriptions, the things that you do to maintain your health care or your medical needs. This person is granted with the authority to assist you. Our documents contain a HIPAA release for that medically protected information so that the agent can communicate with the doctors and have access to the information that's needed to help make those best decisions. You draft this document during your lifetime. People ask, well, what age is the best age to get this? And I say, we don't have one, it's now. And it is at any age, and the sooner the better. I have mine in place, and I've had peace of mind to have it multiple times during my life already. For having a surgery, I knew I had a parent named at that time, just in case something happened. I had one when I had my daughter, just to be very clear what and who is in charge of this decision-making authority related to my health care. And so this document is only valid during your lifetime. And so it operates during that time when you're alive, and when you pass is when the will and the trust would kick in and govern your estate planning and the distribution of your estate. Again, as we've touched on a lot, it's extremely important to name a trusted person, someone that you trust. Does this person have the same beliefs with healthcare that you do? Is this person going to make the decisions that you would make, or maybe they have a different view of what should be included in your healthcare? So that's important to consider. Will this person be available immediately if something comes up? If you need a very quick treatment, a surgery, is this person available and willing to dedicate the time to you? And then of course we already touched on if you name more than one person, what could be a benefit and what could go wrong there. Once you get this document in place, it can be revised and revoked by drafting a new power of attorney for healthcare. So you may decide this person is best suited to be my agent, but a couple years later, maybe that person's not in your life as much anymore, or maybe you have a relative that is now in the healthcare field and you think this person is better suited. They have that background knowledge, so I want to rearrange the order of my agents, or unfortunately someone may have passed away, and so it's important to keep that updated, and also to name successors. If a person is not able to serve for whatever reason, death or otherwise, or maybe disability, that you have successors and your document doesn't fail for that reason.
Okay, good stuff. So guardian is medical and healthcare related, and conservator is financial. And it could be different people. You can also have a professional guardian or conservator, and that could maybe be arranged through you, or what's the benefit maybe of at least knowing that there's professionals out there that you can maybe name? It might be easier for your family, or things might be done better depending on your situation.
Well, you certainly know that somebody who's qualified and somebody who understands sort of the system, right? These professionals, they understand the resources available, they understand how to communicate, with medical healthcare providers and those sorts of things, because this is what they do, and so they're also going to be there, they're local, they're going to be available most likely. I mean, they have lives too as well, and maybe go on and be out of town or something like that. But this is, they're being hired to do this, so it's certainly a good resource there.
And it is something that a lot of people utilize.
Absolutely.
They need to be healthy too.
Sure.
They need to be alive too. So,
Right, and just a quick comment before we jump into trust. The individuals, the trusted individuals that you've named in these documents, it's not a mandatory requirement that they do these things. They're not forced into this responsibility. If something's come up in their life or something's happened, they can say, I just can't take on this responsibility right now. And so in that aspect, a professional, maybe the best situation. I'll let Jason kind of take it away to.
I'll just, because I know we're
we
running
have
short.
8 minutes, so we want to make sure that we mention that trust too. We've got a question here. Who else has questions? So we're going to do a speed dating.
I'm going to do really quick on the trust. So I've got some, when is a trust a must, just because I thought an alliteration would be fun here. But a trust, I have people come to me and they say, I heard I need a trust. I said, well, who'd you hear that from? Let's talk about it. Let's see if that's true. It may be true, it may not. But we want to talk about what is a trust good for. And some things trusts are good for is it's a way to centralize your estate plan. I was talking before about some beneficiary designations here and sort of, a will to handle some property. And that works sometimes, but sometimes something could get missed, or you can have a situation like I talked about before where maybe assets are drained out of one account to provide for care. So a trust, an advantage is a centralized estate plan. The idea of a trust is, if you think about it this way, that traditionally a trust would be something that you would set up where you say, I want to benefit this person with some property, but I can't give it to them outright. Maybe they're a minor. Maybe there's some issue with their life circumstances that it doesn't make sense. So I want them to enjoy it, but I can't give it to them. So what do I do? While I'm alive, I can take care of that. But when I'm gone, what do I do? And so that's where the idea of a trust agreement comes in, where you appoint somebody as trustee. They get legal title to the property. So they're legally the owner, but they are governed by the trust agreement. And the trust agreement is going to say, this is what you can use that property for. Generally, it's to benefit this person. Make distributions to them periodically, pay income, let them live in a house, those sorts of things. So when is a trust a must? Okay, some people say, I need a trust because I want to avoid probate. Okay, well, let's talk about that a little more, because as we already have discussed, that might not be standing alone a good enough reason. So I say, let's answer these questions. What do you want to control the timing of distributions after you die? All of these things we talked about up to this point, be it a will, pay on death beneficiaries, those, you die, property's theirs, albeit state administration. Probate will take a little bit of time, so it won't happen immediately. But when that probate procedure is done, that's their property. Maybe it's $30,000, maybe it's $50,000, maybe it's $250,000. And so that may not be what you want. And so if you want to just delay some distributions to maybe all of your beneficiaries or to maybe one person in particular, or you want to leave things to minors, a trust is something is a way to absolutely do that. If you want continued management.
Oh, sorry, Max.
Continued management of those trust assets, you need to do it through a trust. You say, I want this person to have it, but they're not good at managing things. So you can have a trustee be designated to manage that for them. Blended families, you see this often. We have children from prior marriages, husband and wife. With a will, you see these wills that will leave everything to the husband, everything to the wife if they're alive. Sometimes it works. Families are all different, but you would probably not be surprised that when maybe a spouse dies early, the other spouse might remarry. The other spouse might not stay as connected with the stepchildren. And then all of a sudden things change, and when that surviving spouse dies, everything goes to his or her children. And so one way to protect against that is to have a trust that says, maybe when the first spouse dies, the assets will remain in trust for that spouse's benefit for his or her lifetime to take care of all their needs. But when that second spouse dies, then our plan is going to distribute. And it's not always, I tell clients, even if you trust your spouse, there may be a pressure campaign that starts after you die, after one of you dies. And they may have good intentions, but they're going to get older. They're going to, you don't know what their circumstances, maybe more vulnerable, maybe more susceptible to influence. And so it's not always trusting that person, but sometimes protecting that person so they can say to their kids, sorry, your dad and I or your mom and I had this in place, can't change it. We don't need to talk about it. So.
I think that's one of the most important things you've said, that just creates peace, so, well, nothing I can do. And another reason why trusts sometimes are used, let's say you want to leave property to a granddaughter, but you don't like your current boyfriend, like really don't like him. And so it might be getting with you to talk about trust.
Yeah, and there's also some creditor protection. Kansas, we're not a state that you can put your property into a trust and still use it and your creditors can't reach it. So sometimes people want to do that. There's not really a good way to do that. Kansas law says, hey, that doesn't seem right, But what you can do is when you pass property on to children or whoever your beneficiaries are, you can provide them creditor protection. So if it's not their asset, because it's in this trust and their creditors can't reach it, and so maybe there's somebody who's in an industry or a field that they may be susceptible to being sued. Well, if they may become a bigger target if they have assets in their own name. Or maybe you have somebody who has special needs and who is entitled to government benefits. You can, and if you left them assets, they would immediately be disqualified from receiving those government benefits. So you can set up special need provisions, a special needs trust. If drafted properly, they can continue to qualify for those benefits, and then those assets you leave them can be used to supplement their life, make their life even better. They don't have to live on the bare minimum that may be provided through Social Security or Medicaid, but they'll get those benefits, and then you can supplement.
Wow, you see why they go to school so long? And then they specialize in different things. There's so many complexities, and that's why the best answer is it depends. Go to the people that specialize it, okay? Because you're gonna have a lot of questions when you're really digging into all these things. So, and we have 2 questions here.
Well, I know with time allowed, you're not gonna be able to answer all of this, and that's okay. But I wanna just put it out there so that if I come and meet with you, that you could answer these questions. And my question is, I'm concerned about if I were to later have to go to a care home and my son is supposed to get my property, kind of how you could help with that. I mean, if that's something he just does on his own, he sells my property to pay for my care, if I have to go in a care home, or just kind of those kind of questions. And I realize time is not, something you can do right now, but is that something you can even answer questions about?
Of course they can. Also, that's part of what we do, Senior Transition Specialist, is help people weigh all their options and plan some to step out in advance, give you some of the background information so you kind of have a plan, and then you can get with the attorneys and you guys talk it all through.
Absolutely, and what you're talking about is, I think, kind of Medicaid planning, sort of preparing for having to go into long-term care and saying, well, boy, Medicaid's gonna make me spend all the way down to $2,000 before I qualify. I don't wanna do that. The Congresses, the taxpayers of the state of Kansas say, well, we do want you to do that. We don't wanna be paying for people's care when they have plenty of resources to pay on their own. We don't actually hyper-focus and specialize on Medicaid planning. Because there are just some great experts, some in Wichita and some in other cities that we can certainly refer you to, who would do a tremendous job helping you navigate that, because it is very it's a very niche area, and you don't just want to get a sort of shade tree Medicaid planner. Right. Because the ones who do it and dedicate themselves to this work, we know people who do that. They know it inside and out. They know all the things that you can do to really enrich get the most for you while still qualifying.
Yes, so they'll help advocate, make sure you get the care that you're entitled to. Okay, so we're gonna ask some quick questions here and see what we can get answered, then we're gonna wrap it up.
Too quick. Number 1, does a trust have to go to probate just like a will does?
Does the trust have to go to probate just like a will does?
Ideally, no. If the trust is properly funded, meaning you've dealt with your assets, titled them in the trust, then it is an instrument that can avoid probate. Now, if you later purchase some real estate or something and you do not put it in your trust or title it appropriately, there are some ways that we can do kind of a simplified probate proceeding to pour it over, to get it into the trust, because it was your intent by creating the trust to have everything in your trust, but you accidentally missed an item. So, that's why we say the trust, funding the trust is an ongoing process. It's something to consider, throughout the entirety of your lifetime. But properly done, yes, it does avoid probate.
Okay, the second point was, all of my life, I thought that the spouse, if one died, the spouse automatically gets the house and so on. Now, today, for the first time, I'm hearing, no, that's not right. So we've got two families. We've got kids from each side, but none together. So if I were to die first, my husband gets half of it, and his kids or my kids, what?
Well, it depends on how the house is titled.
It depends.
First of all, it depends on how the house is titled. There is some, if the house is titled in one spouse's name and not the other, and that spouse dies, the surviving spouse does have what are called homestead rights. And so long as that surviving spouse continues to use that home as a primary residence and does not remarry, they can continue to occupy the home, even if ownership may transfer half to the surviving spouse and the other half among the kids. So there are rights that the laws in Kansas are in place to protect spouses, but as far as that only applies generally to the house, though.
And so we've had people sign their house over to one child and one grandchild. The other two children and other grandchildren were not on the title of the home, and mom had to move out. I mean, all kinds of crazy things. So don't try to navigate this on your own if maybe you didn't go to law school as long as they did. And then still maybe you should talk to them. Talk to the lawyers that specialize in it. Because that's what you do. You refer to other lawyers for different areas of specialty, right? This is your specialty.
Absolutely. As I mentioned before, we have 24 lawyers. If there's business, tax, real estate issues, we've got people that we can pick their brain and answer questions maybe we, don't know the answer to, or we just kind of want to bounce something off of.
What happens when you have a child named, an adult child named in your will to receive X amount of dollars or whatever, and they refuse it?
So that is absolutely an option. The person can disclaim what is entitled to them through estate planning. If that's the case, I would hope your estate planning is robust enough to have a provision in there that says what happens in this situation. Something we always include in ours is what we call a contingent disposition or a disaster clause, or something that happens where either a situation where the intended beneficiary or beneficiaries do not or cannot receive, maybe because they're passed away or they choose not to receive. We provide for a situation where that may occur.
Okay, so, correct me if I'm wrong, this is not like legal advice from the stage. We're just providing a little education, trying to give some awareness that there's a lot of complexities, and to sit down with professionals and sooner rather than later.
Absolutely. I was about to talk here very fast, like the end of a Pfizer commercial, and tell you about how
We want to hear that voice.
this isn't legal advice, because we have to be able to sit down with you, and everybody's situation is different. It depends. That's the key takeaway. And so it's important, there's just not really, there's general advice in terms of what we've talked about today, but whether or not any of these things we've talked about fit into your particular situation is going to depend.
All right, so we have a comment. Gentleman asked the nurse why adult diapers are called Depends and baby diapers are Loves, Pampers, or Huggies. That's awesome. So someone's replied, well, you can get almost anyone to change a baby diaper. When it comes to adults, it depends. We're good at topping off better than that. Do you think you'll remember that? What's the answer? Yes. Who knows what to say after it depends, ... Jason, Amy. Okay, so let's see here. Conclusion. Oh, you had a conclusion. You really provided so much content. It's so great. Give us the last word.
Yeah, quick conclusion up there. It's reflect on your values, your objectives. Reflect on your family situation, your family dynamic. You got to think about that. A lot of times I tell people it depends in meetings because it really, what are your circumstances like? And what do you have? And what do you want to do? What's important to you? And then also plan. You got to create a plan. Once you have done that reflecting, then let's put a plan in place that works for you and then review it. Whether that's every year or every 5 years, certainly whenever there's been a significant change in your life circumstances with a child, grandchildren, maybe a spouse who's no longer around, come back, revisit that because you may want to make some changes. I see people a lot of times come in with a will or trust or something they've done 10, 20, 30 years ago and hadn't made any changes. And their executors and trustees are all dead. They, they're estranged from maybe a child or maybe a situation that they wouldn't, want to include them or something. They have grandchildren now. They have more assets than they did. So reflect, plan, and then review.
Awesome. Don't forget, you can go around, there's good stuff here in the room, there's good conversations you can have from all the education partners. And for Amanda back there with Gleason Gooing, Amy and Jason, thank you so much for putting this program on today. Thank you. Did you get your money's worth today? I hope so. We are going to have the second Thursday of next month, like always, we're going to have a Christmas program. So come to that. We're planning that now. We'd love you to be here. They're going to have some Christmas decorations in the air. It's going to be gorgeous outside. I hope you take advantage of having your free admission to Botanica today. At least go out and see something. At least go out and see one thing. We're going to get a photo, and then you can come up and ask questions or chase them down if you can catch them. And come give them a hug.
There are homes for sale. Anyone who wants to get the homes, they're out by the butterfly house. We'll pay $200.
Okay, there's mums for sale. And so you can talk to Botanica about that opportunity. Well cared for mums. You might want to check that out. Thank you so much. I'm Catherine Ambrose. This is Empowered Senior. Thanks for being here.